Good morning. Are you Tristan Calhoun? Yes. And will your client waive the formal reading of the indictment in each case?
He will, Your Honor.
Mr. Calhoun, in clause number 25, DCCR 1216, you're charged with the second-degree felony offense of aggravated assault with a deadly weapon from August 2nd of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And because you did what they charged you with? And then in clause number 25, DCCR 1217, you're also charged with the second-degree felony offense of aggravated assault with a deadly weapon from August 2nd of 2024. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? Bless you. I have here on the tablet some documents that have your signature on them in each of these cases that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes.
Do you fully understand them?
Yes.
And do you understand if I follow the agreements that you've reached with the district attorney's office, you will be waiving or giving up any right to appeal?
Yes, ma'am.
So you can't change your mind if I follow the agreement. You understand?
Yes, ma'am.
And it looks like the agreement that you've reached in each of the cases is for 7-year deferred probations. There would be $500 fines. There would be, you'll be required to follow all of the rules and conditions of probation, including paying any restitution that would be determined between now and when we come back for sentencing, and also having no contact with the victims in either of the cases. Do you understand?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Calhoun is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your case, both of them, for sentencing so that the probation department can do a pre-sentence report. Again, that'll give me more information about you, your cases, determine any restitution, and then we'll come back later for sentencing. What's the state's position, Ms. Malfino, with regard to bond based on the nature of those plea agreements?
Judge, I have no objection to the PSI bond in this case. It appears he only has one misdemeanor conviction from years ago. For my review of his criminal history, I would ask, as the court has already stated, that he not have any contact with Sierra Williams or Keithera Fowler, the complainants in these cases. It doesn't appear that these parties know one another. It appears like this is more of a road rage, traffic accident gone wrong type thing.
What was the first name? Sierra
Sierra Williams and Keithera, Keithera Fowler.
The indictment on that one says Ardwan as the last name. Yeah, that's the 1217. And I can just put
Yes,
both.
it does, so she must go by both names.
Okay, so Fowler, Ardwan.
Correct.
All right, so
And then
he,
not, I'm sorry, excuse me.
Sure.
That he not possess a weapon because it was involved in this case. I will get together the necessary documentation for their medical restitution to assist PSI.
all right.
I think the car was still dead. They're alleging the
Was-
car.
The motor vehicle,
They're alleging the car was still dead.
let me look at the probable
Probably
cause.
there's a,
There-
yeah.
I can't read this. I'm printing something real quick.
Yes, ma'am.
So what I'm going to do while I'm printing that is, Mr. Calhoun, I'm going to reduce your bond in each of these cases to $1,000. If you make those bonds, a condition of those bonds are that you obviously have no contact or communication with Sierra Williams or Keithera Ardwan Fowler. Give me just a second. I'm taking that back. I'm not gonna change the bond because there's the potential of some type of upfront, either treatment or cognitive issue. I mean, what happened on this day this is pretty serious. Yeah, and so, the bonds are going to remain the same. I'm not gonna reduce those bonds. We'll see what the probation, what that report comes back, and if I feel like there's anything that is necessary or would be helpful for you to be able to make better decisions, be successful in the probation, then I'll order that at this time, but I'm not gonna reduce the bonds based on what happened that day. All right, you can go back with the bailiff. Good morning, you're Donnie Williams. And Mr. Parker, will your client waive the formal reading of the motions in each case?
Yes, Your Honor.
Mr. Williams?
The charges are all the same in each case, Judge.
Yeah, I gotta go through them. Okay. In cause number 22-40823, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation February 13th of 2023 for forgery of a financial instrument, a state jail felony. That was a 2-year sentence that was probated for 5 years. Is that correct? And in cause number 22-41018, I also have a first amended motion to revoke your community supervision. Again, also shows you were placed on probation February 13th of 2023 for forgery of a financial instrument, a state jail felony. And again, that was a 2-year sentence that was probated for 5 years, correct? And then cause number 22-41019, also have a first amended motion to revoke your community supervision. Also shows you were placed on probation February 13th of 2023 for forgery of a financial instrument, a state jail felony. That was a 2-year sentence that was probated for 5 years. Is that also correct? Speak up, please. Thank you. All 3 of these motions allege that you violated your probation. Count 1 alleges in each case that you failed to report as directed to the probation department December of 2024 and January of 2025. And is that true or not true?
True or not true?
True.
Count 2 in each case alleges that you failed to provide verification of completing the theft program or the theft prevention class. Is that true or not true? Count 3 in each case alleges that you did not provide verification of entering and successfully completing the moral recognition therapy. Is that true or not true?
MRT program.
MRT. True.
That's what we talked about.
Count 4 in each case alleges that you are behind in your court-assessed fees. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 in each of these cases freely and voluntarily? And did you plead true because all of those counts are actually true?
True.
In each of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed those, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, Mr. Williams, in each of your cases, I'm going to find that you enter your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to revoke your probation. In cause number 22-40823, revoke that probation, reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 22-41018, Find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 22-41019, find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence also for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm going to hand you the trial court certifications in each of these cases that shows these were agreements that I followed, and so you've waived your right to appeal. When you entered your pleas in these cases, I went over with you the fact that you're ineligible under Texas law to possess a firearm or ammunition. I'm attaching a copy of that because of the judgments. You are ineligible to possess a firearm or ammunition, and if you have questions about that, you can read that document or talk to Mr. Parker. All right? Good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
Thank you. All right, are you Robert Lowe?
Yes, ma'am.
And so Mr. Lowe was previously in court, entered pleas of guilty to 3 cases of possession of child pornography. There was an agreement in those 3 cases for a 7-year deferred probation and a $1,000 fine with dismissals, I think, in 3 or 4 other cases. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
I feel like this is different from some of these types of cases because Mr. Lowe was actually involved in creating with his own family member victim who was very young, 5 years old. So this wasn't I downloaded something and didn't realize what I was downloading. This is very different. This is a family member that was victimized because of this. Don't talk right now, okay? And so for those reasons, I do not feel comfortable accepting deferred probations in these cases. So I'm going to reject those plea offers. I don't know, honestly, I haven't thought more about what I would be amenable to other than potentially just letting a jury decide. I'll reset it one time, you guys negotiate, see where you are on it, and if you come up with something, you can contact me. Otherwise, we'll get rejections and get his cases set for trial and let a jury decide one way or the other, okay? I'm just not comfortable with this at all. You can go back with the bailiff.
But I already signed for probation.
I don't have to accept your probation.
I wasn't told that.
Yeah, you actually were, because we reset your case for sentencing. And here's the thing, it doesn't matter if you were or not. I'm not accepting the plea agreements, okay? There's nothing you can do at this point other than Ms. Holmes will be out there to visit with you about any other options. And if you don't like those options, or if I don't like those options, then ultimately, that's what a jury is for. If everyone can't agree, and then we get a jury to come in and determine if you're guilty and what the punishment is, if you are found guilty, okay? So let's see where we're, I'm not gonna consider any bonds at this time.
Yes, Your Honor. I just, his mother is here, and so, but just for the record, because I have spoken with her on several occasions as well, as with Mr. Lowe, they did keep asking me if he would get out today, and my response to both of them was that it's up to the judge at the
Okay.
end of the day. So
Thank you,
I
Ms.
told you
Holmes.
that yesterday
Yes, ma'am.
when I visited with you,
Yes, ma'am.
and I told that to your mother,
Yes, ma'am.
that ultimately it's up to the court on whether you would be released today and placed on probation.
Yes, ma'am.
Thank you, Ms. Holmes. You can go back with the bailiff.
I can't say nothing else.
It's probably not wise right now, okay? Go back with the bailiff. I'm going to delete the other dismissals that came through at this time.